Namaste and greetings. I, Ritika Pandey, researcher at IMPRI, Impact and Policy Research Institute, Prabhav एवं नीति अनुसंधान संस्था नई दिल्ली, extend my warmest welcome to you all to IMPRI, Web Policy Learning. Today, we are gathered here for the final day, that is, day 6 of the LPPYF Law and Public Policy Youth Fellowship, Cohort 3.0. The theme for this cohort is Advancing Justice, Bridging Gaps in Public Policy Enforcement. We welcome you to join us for an immersive journey into impactful policy and action. The chair for the program is Professor Vibhuti Patel ji, visiting distinguished Professor IMPRI. The legal advisor for the program is Advocate Dr. Shalu Nigam ji. Our expert for the program includes Professor Saumya Umaji, Professor Jindal Global Law School and Director, Center for Women's Rights. Professor Vibhuti Patelji, visiting distinguished professor, IMPRI. The conveners for this course are Dr. Ajay Gudavardi ji, Advocate Celine Thomas ji, Dr. Sime Mehta ji, and Dr. Arjun Kumar ji. Proceeding further, we welcome everyone to this transformative journey and appreciate your dedication in investing your time, energy, and commitment to gaining a profound understanding of the crucial role and intricate details of policy and action. We have also shared course outline and reading resources in your email for your kind pursuit. Before we start today's session, I would like to state the housekeeping announcements. Please join the meeting on time. There will be a Q&A session after each presentation. Share your questions on the Q&A box. The questions must not be posted as an anonymous attendee. Ensure that your questions are precise. Refrain from making general comments in the question to save time. To begin today's session, I would like to invite our chair, Professor Vibhuti Patel ji, visiting distinguished professor IMPRI, to give her opening remarks. We welcome you, ma'am, and over to you.
Thank you, Ritika, for introducing the course. Today we are on the concluding day and we are going to have a very, very interesting sessions. Both the sessions are going to add to new knowledge. And briefly, like what all transpired in the previous sessions, we know it all began with the right to speedy justice, the discussion on how the grassroots initiatives contribute to the new understanding and policies. We also deconstructed the concept of democracy, democratic governance, and what are the hurdles and challenges we are facing, and so many legal hands-on that we have had. And today, now in a concluding session, we are going to have a discussion on intersectional vulnerabilities and affirmative actions for elderly, person with disabilities, Dalits, ethnic minorities, religious minorities, and sexual minorities. As you can see in the very first slide, we get the way our country has defined. First of all, we have a special commissions to address the needs and demands and aspirations and dreams and problems and challenges of this intersectionally vulnerable sections of society. First of all, it would be, we have a scheduled caste and scheduled tribes welfare schemes and commission. We also have a senior citizens laws regarding senior citizens. We are also committed to gender equality, and the way state has identified minorities, they are supposed to be Christians, Muslims, Sikh, Jain, Zoroastrian, and Buddhist. Now, coming to the question of, first of all, what do we mean by intersectional? Oh my, how do I? Yeah, so intersectional approach, why it is very important? Because there is inequality and discrimination in the society, and it cannot be understood by only single axis of identity or a caste. We need to have or gender identity or a religious identity. It has to be examined and explored through an intersectional lens, where multiple and differential identities, they are playing a very important role. And according to Sandra Friedman, structural intersectionality is a more useful approach as it focuses on the need to redress disadvantage, need to address stigma, stereotyping and prejudice and violence, and also need to facilitate voice and participation, and need to accommodate difference and change structures of discrimination. Now, for us, the touchstone of this intersectionality and the intersectional understanding is that of a Constitution of India. And as per the Constitution and its fundamental rights, we have Article 14, 15, 16, 73rd and 74th Amendment we had in a Constitution, by which 1/3 of the seats were reserved for women. So our Constitution is extremely progressive. Though it was adopted in 1950, it was much ahead of its time in terms of the progressive content in it and the socially inclusive policies, laws, and the provisions and facilities that were given. Directive principle is another very important aspect of Indian Constitution as per Article 39, which enjoins the state to provide an adequate means of livelihood to men and women, and also it also talked about equal pay for equal work, which eventually in 1976 India passed a law, the Equal Remuneration Act. Article 42 talks about the state to ensure provision for just and humane condition of work and maternity relief. And the state is also enshrined, the Constitution has also demanded from the state fundamental duties in terms of renouncing any practice which is derogatory to dignity of women, whether it is a widow burning or female infanticide or discriminatory behavior between men and women, girls and boys. And also there is a financial accountability. On 23rd of July, there will be budget presented by Finance Minister in Parliament of India. Now, in every budget, like the union budget or a budget of the state or a sub-national level budget, which is called, it has to be prepared and placed before the Parliament and state legislature respectively, because it is a public fund and it has to be sanctioned and it has to be passed by the elected representatives. Now, when we talk about affirmative action, social security and social protection, these are extremely important concepts for the 21st century humanity. Affirmative action refers to the act of positive discrimination through supportive measures to empower the intersectionally vulnerable groups, that means minorities in the societies, and come up with the policy and also and the minorities who are not taken care of in the policy. You may have a policy of education for all, but there is inequality in the society. The boys will immediately get into educational institution, but girls will be left out. So you have to come up with the affirmative action, say that, okay, in education for all policy, that means Sarva Shiksha Abhiyan, minimum 30% of the enrollment should be that of girls. Otherwise, they will be left out. And that's what happened in 2000 when this policy was adopted. It is so affirmative action is used as a policy intervention measure by governments, also corporations and civil society organizations, to help the marginalized sections access better occupational and livelihood opportunities. Now, social security and social protection globally, if you see, they are used interchangeably. In India, we have defined social security as a human right, which responds to the universal need of protection against certain life risk. It can be accident, it can be disaster, it can be health emergency like COVID, or some of the special social needs that elderly people have, people who are suffering from a long-term illness or at the time of maternity or death or unemployment. So all these are some of the critical emergencies that human beings face, and we need to, the state provides social security. Now, according to International Labour Organization, social protection or social security is a human right and is defined as a set of policies and programs designed to reduce and prevent poverty and vulnerability through life cycle. Now, social protection includes benefits for children and family, maternity benefits, unemployment allowance, employment injury while working. If you get workplace injury, you have to be compensated. If there are major disasters such as a deluge or a floods or famine or health emergencies, then the state has to take responsibility to look after the population without charging anything from them. and also the question of sickness, old age, disability, all these things, survivors of violence, all of them need to be protected. And the social protection system address all these policy areas by a mix of contributory schemes. So it can be either contribution by the employer and contribution by the state and contribution by the person. That means when we do the mediclaim, or when we when we pay premium for life insurance. So there are multiple agencies which are taking responsibility of social protection. When it comes to employee state insurance scheme, ESIS, where employer gives 1/3, employee gives 1/3, and the state, the government, they give 1/3 of the 1/3 contribution for social security. Now, another very important concept that we need to understand here is question of rights, which are which right-based approach. Because right-based approach starts with the premise that where there is a inequality, where there is a subordination domination relationship, where certain people enjoy the fruits of development and others are left out. And on paper, you have equality. What do you need? You need affirmative action. You need social security. So you can see in this poster, the first stage where a child on the left side is able to enjoy fruit because there are so many fruits, and child, the fruit drops on his hand. While the other side, there is a scarcity of fruits and child doesn't get anything.
मैम स्क्रीन में हमें फर्स्ट स्लाइड ही दिख रहा है.
क्यों ऐसा? मैं छोटा कर दूं?
नहीं नहीं, ये ना आप अगर बॉटम लेफ्ट में जाएंगे ना तो वहां पे आपको दिख रहा है क्या?
बॉटम लेफ्ट दिख रहा है, हाँ.
वहां पे कर्सर दिख रहा है? नहीं. एंड शो नहीं, मतलब उसको चेंज करते जाए. क्या मतलब वहां से स्लाइड्स चेंज नहीं हो रहे हमें, क्योंकि फर्स्ट स्लाइड ही दिख रहा है.
ओ बाप रे, ऐसा कैसे? तो वो निकाल दूं मैं? शायद बैंडविड्थ का प्रॉब्लम होगा.
नो नो मैम, वो ना कुछ चेंज नहीं हो रहा.
अच्छा, अभी हो रहा है? ओ यार, ये मैं पुराने अपने इसमें चली जाऊं?
यस यस यस.
तो क्या करूं मैं अभी?
स्टॉप शेयर
कर दिया.
then again
now I'll just go use the
normal
ना. हाँ, तो नॉर्मल कैसे आएगी?
शेयर स्क्रीन, फिर वो
मैंने शेयर स्क्रीन किया मैंने. हाँ,
फिर वही बेसिक में बिल्कुल वो जो आता है ना,
बेसिक आ ही नहीं रहा अभी, बस वो पावर पॉइंट एज वर्चुअल बैकग्राउंड आ रहा है.
नो मैम, ऊपर एडवांस के बगल में बेसिक चूज कर लीजिए.
बेसिक है, हाँ, आ गया. ओके ओके, गॉट इट. यस, फाइन. तो ये जो मेरा था वो पहला स्लाइड था जिसका मैंने आपको बताया. So this I explained that what are the different policies. Here we also understood the intersectionality and structural intersectionality. Then I spoke about the fundamental rights and then directive principles.
Is it full screen for you?
हाँ.
नहीं, हमारे लिए तो नहीं फुल स्क्रीन.
तो क्या करूं मैं?
स्टॉप एंड रीशेयर.
स्टॉप एंड रीशेयर.
रीशेयर करेंगे ना तो 2 विंडो दिखेगा, एक फुल.
हाँ, ये हुआ. अभी रीशेयर क्या?
हाँ,
हाँ, अभी क्या करूं?
मैम वापस से उसी को सिलेक्ट कर लीजिए.
किया मैंने. आ गया? करूं फुल स्क्रीन?
वर्किंग फाइल दिख रहा है.
हाँ, लेकिन करूं फुल स्क्रीन?
हाँ मैम, ट्राई. यस,
आ गया. फुल स्क्रीन आया?
नो.
क्यों आज ऐसा हो गया? नहीं तो कभी नहीं होता ऐसा. तो क्या मैं वर्किंग में रखूं?
यस यस मैम.
ओके, शायद बैंडविड्थ का प्रॉब्लम हो. ओके, तो ये जो था, तो पहली जो सेकंड स्लाइड इज इंटरसेक्शनल अप्रोच, उसकी द डेफिनेशन एंड हाउ वी अंडरस्टैंड इट. Fundamental rights in the Constitution of India, directive principles in the Constitution of India, definition of affirmative action, where is the positive discrimination, what do we mean by that, how social security has been defined in our country, and also ILO's definition and the universally the UN system, whether it is a UNESCO or UNICEF or UN Women or WHO or all the UN bodies, they use social protection and social security interchangeably. Then we come to the right-based perspective, and where here I was, that when there is an inequality, some people are enjoy the fruits of development, others don't. But there is a formal equality, there is a promises there. But what we need is if we treat in equality, you treat everyone equally, which is also wrong. All people who are in unequal position cannot be treating them equally is also injustice. Okay, the needs of children are different from needs of adults. The needs of person with disability are very different from that of able-bodied person. So treating people equally when they are in an unequal position is also wrong. What we need is equity. Equity means that the people who are the sections or the vulnerable people who are left out of these advantages, they need a longer ladder to get the fruits of development. That means more affirmative actions and more special attention is required, along with the overall equality that you are promising to whole population. And even after equity, there are so many prejudices based on caste and religion and ethnicity and gender. We also need justice system. So those who resort to violation of human rights, they should be brought to book. So the criminal justice system also, it has to be very, very conscious. And I think we had all previous 5 days where several experts, including Dr. Shalu Nigam, in her legal hands-on, she took up various aspects of the justice system. Now, overarching framework that we have in globally is a Universal Declaration of Human Rights. We all know that there were 3 generations of human rights. In Dr. Vaida's presentation, she went into details of it, and where we talk about all human beings are born equal and their in dignity and rights. So examples of international human rights are, one is the International Covenant on Civil and Political Rights, 1976. UDHR was adopted in 1948. Now, International Covenant on Economic, Social and Cultural Rights, again in 76. Convention on Rights of Children, that is 1990, and Convention on Elimination of All Forms of Discrimination Against Women, 1979. We call it CEDAW. And Convention relating to status of refugees, that was in 1954. And we had so many upheavals, political upheavals, which had taken place in the time, like so many African countries got liberated from the colonial regimes. In Latin America, so many turmoils were taking place. Several Asian countries, they had a fight against colonial rulers, and whole of Europe and America, Europe was affected. Even Japan was affected by the aftermath of the Second World War. So it was very important at that time. Now, in our constitution, as the preamble of the constitution talks about justice, liberty, equality, and fraternity, and also the fundamental rights which are enshrined in our constitution, they become very important in terms of providing social security and social protection. So intersectional approach, it takes the historical, social, and political context into account, and recognizing that vulnerable and marginalized groups are neither homogeneous nor static, and that different factors will influence their ability to prepare for or cope with or respond to the stress. So any stress, whether it is a stress in terms of unemployment, stress in terms of overall political situation, which is where democratic rights of peoples are curtailed, or whether it is the emergency in terms of long-term illness like cancer and all. So we need to understand what is the position of a person in terms of class, religion, gender, race, age, sexuality, education, language, ethnicity, history, and heritage. So, so many times, all these factors are overlapping. They are not independent. They are overlapping and they are intersecting in terms of social identities, and they are also related to the systems of oppression, domination, and discrimination. So the class-based intersectional vulnerabilities, if we see, it is a both in the macro policies, economic policies, whether your country is a welfare state, whether you have a social sector budget, and in terms of a micro at a local level also, what kind of measures you are taking for the welfare of children, or your country's immigration policy, the legal system, your educational system, and even your foreign relations. Like we had this 3-day course, the feminist foreign policy, how it becomes very important even to negotiate more and more social justice space and democratic governance in the and also with the intersectional understanding in the foreign policies also. Now, caste-based vulnerabilities, when we talk about, and the constitutional guarantee as per the Article 15.4 and 16.4 of Constitution, which enables the state and central government to reserve seats in government services for members of scheduled caste and scheduled tribe. Now, Constitution was amended in the 77th Amendment in 1995. A new clause was added, 4A, which was inserted in Article 16 to enable government to provide reservation in promotion. So that also now, but it's in the public sector that is happening. Now, Article 17, which talked about elimination of untouchability, and also Article 46, which promotion of educational and socio-economic interest, which mandates that states shall promote with particular care and the educational and economic interest of the weaker sections of society. Now there is a new clause added that economically weaker sections should also be looked after. But here we are talking about the scheduled caste and scheduled tribe, and there is a special budgetary provision. It is called Scheduled Caste SCP, Scheduled Caste Plan, and TSP, Tribal Sub-Plan. In Article 335 of the Constitution, which claims of scheduled caste, where filling positions in connection with the affairs of the union and state governments, and consideration for the claim of those who belong to scheduled castes and scheduled tribes must be given while maintaining administrative efficiency. That means that they also need to qualify for these positions. Article 330 and 332, they talk about reservation policy, where the set aside seats in the House of People, that means Lok Sabha, and the State Legislative Assembly for members of scheduled caste and scheduled tribe, and the reservation in local bodies. As in 1994, we had a Panchayati Raj Act, by which 33% seats were accorded to women. Within reservation also, we need to have a reservation for women from scheduled caste and scheduled tribe. Constitutional guarantee in terms of Article 338, where the National Commission for Scheduled Castes was formed, and its functions include investigation and monitoring of all matters relating to constitutional and other legal safeguards, and also inquiring into specific complaints with respect to deprivation of rights of and safeguards of scheduled caste. And the 338A also makes the state responsible for not only establishment of National Commission for Scheduled Tribes, but also providing them enough resources for its efficient functioning. And the Scheduled Caste and Scheduled Tribe Atrocities Act was passed in 1989, where punishment for the offenses of atrocities against Dalits and tribals, punishment for the neglect of the duties by the police officers, the district magistrate, and the government officers, and also enhanced punishment and subsequent conviction if you don't perform your duty at the time of atrocities against them. So the functioning of various wings of NCSC, National Commission on Scheduled Caste, first is the atrocities and protection of civil rights. Another thing is the service safeguards, where in the employment, in terms of recruitment, in terms of treatment, in terms of promotion, you have to provide them a special quota. An economic and social development wing, which also talks about the scholarships and freeships and extra coaching for scheduled caste and scheduled tribe children, and coming up with the special measures so that they can come up to compete in all the exams, and also in terms of educational opportunities, job opportunities. So scheduled caste and the plan, when you have it, is a budget is provided in the union by the union government and also the state government, and National Commission for Scheduled Tribes is also there. So both of them have been allocated funds, functions, and functionaries for efficient implementation of the law. And now coming to another vulnerable group, that is a gender-based intersectional vulnerabilities and women's response of the social movement in the state. And we have seen right from the social reform movement, freedom movement, this has been a central concern. So what we see that unlike, in case of women's question, like affirmative actions are required at all levels. So because women, irrespective of their class, caste, race, religious background, they face one more, they suffer from one more layer of oppression, exclusion, injustice, and discrimination. So public-private dichotomy, which is created, which comes in the way of women playing important role in all sectors of economy and all walks of life. For that also now a lot of discussion is taking place. What kind of affirmative action state can say? One of the examples is that of a gender gap in employment, gender gap in political structures, gender gap in promotion in the corporate world. So a government of India and in the Parliament of India unanimously passed Women Empowerment Policy in 2001, which has 4 different aspects. One of a welfare, other one is access to education, access to healthcare, access to political structures, access to educational opportunities, access to employment opportunities, and also public awareness, how to deal with the gender stereotypes, what is going on in the name of custom and tradition. We need to bring the egalitarian ethos in the day-to-day public discourses and also in the practices. And also participation, increasing women's participation in all walks of life and all decision-making bodies. Now, we also got a Maternity Benefit Act way back in 1961, and in 2017, after massive campaigning by International Labour Organization, the maternity benefits were increased from 3 months, it became 18, for 6 months, 26 weeks from the previous 12 weeks. Earlier it was 12 weeks, now it is 26 weeks, and also 15 days, 2 weeks of paternity benefits for male employee. That has also come up in this thing, but it is limited to organized sector. But we also have Janani Suraksha Yojana for women from the poverty group and women who are in the poverty group. So even informal sector women are covered. Now, in the labor laws also, like we have criminal laws, we have civil laws, we have labor laws. Dr. Shalu Nigam, in her legal hands-on, has taken care of in criminal laws as well as the civil laws in great detail, and women-specific provisions in the labor laws, whether it's a Factories Act, where the Section 34 provides for the state government, they can lay down rules prescribing how much weight that should be carried by women and men, whether they are working in a pharma industry or whether they are working as a sugarcane cutter, how much can be, or bricklayer. Then we have a Contract Labor Abolition and Regulation Act, where there is a separate provision of utilities for women and fixed working hours. That means even separate toilet, separate change room, all these things are also provided. These laws have proper implementation mechanism. There is no provision for monitoring. So the laws are progressive, but monitoring doesn't happen from the factories inspectors office or the local self-government bodies. And allowance for special provision for women, they have often proved to be detrimental in short run. For example, night duty, like if you say that women, it's a controversial issue. So the employers would always use that as a excuse for not employing women. or maternity benefits. If we employ women, we'll have to give them 6 months of leave. So this kind of a thing, but that doesn't mean that we don't give this kind of allowance. We have to fight, and we have to constantly have a dialogue with the employers, and to say that this is the duty which women are performing for the economy, for the society. If they produce these babies are going to, after 20 years down the line, they are going to contribute to the economy. So don't see it as a personal problem, and be responsible. Now, another very important affirmative action we have had is it's a participation in decision-making, 73rd and 74th Amendment, by which in 1994, we have got nearly more than 1 million women who entered the Panchayati Raj institutions, and now more than 20 states and union territories have opted for 50% reservation for women in local self-government bodies, both in urban and rural local self-government bodies. As a result, we have 1.8 million women in the public life, in the local self-government bodies. And our parliament also passed a women's reservation in legislature and the lower and upper houses of the parliament in September 2023, but it will be implemented in 2029. So gender-based intersectional vulnerabilities of LGBTQIA community, IMPRI had organized several courses on beyond gender binary, but I think some of the landmark judgments, whether it's a NAS Foundation versus NCT of Delhi, where the treating consensual homosexual sex between adults as a crime is a violation of fundamental rights protected by Indian Constitution, was the judgment. Another important judgment was in 2013, where Suresh Kumar Kaushal and versus NAS Foundation, where two judge Supreme Court bench consisting of Justice Singhvi and Justice Mukhopadhyay, they overturned the Delhi High Court case of NAS Foundation versus Government of NCT of Delhi, and reinstated Section 377 of IPC, which was a major defeat for the LGBTQIA community. Lot of mobilizations and protests took place, and National Legal Service Authority's Nalsa judgment in 2014, which was very progressive, which recognized transgender people as third gender by Supreme Court of India, affirming that fundamental rights granted under Constitution of India will be equally applicable to them. And it also gave a right to self-identification of their gender as male or female or third gender. And then we had a 2017 KS Puthuswamy versus Union of India case, where privacy, the right to privacy was need to be protected. And it's a fundamental constitutional right under Article 14, 19, and 21 that was conveyed. That was the judgment. And then Navdeep Singh Johar versus Union of India in 2018, where the right of equal citizenship to LGBTQIA community was granted, and also Section 377 was fully replaced along with the rest of Indian IPC by even Bharatiya Nyaya Samhita has also repealed it. And the Transgender Persons Protection of Right bill, which became an act in 2019. There are many objections. For example, the penalty for sexual violence, and another thing that who decides whether the gender of a person. These are a contentious issue, and LGBT community and the transgender community is mobilizing, fighting, registering their protest on different platforms. So these two, less punishment for rape of transgender person is an extremely objectionable clause within the act, and also no reservation in job and education. That means you are not, state is not taking responsibility for making developmental investment in transgender community who are abandoned by their own biological families. So these are very important concerns. Now, coming to the ethnicity-based vulnerabilities, where we see that the ethnic minorities face discrimination in education, employment, access to public places, and with the policies and authorities, and also they are generally experiencing discrimination within their families also. And tribal people, they find it harder to be supported by professional associations such as Lawyers Association or whenever they face discrimination, their access to justice is also very limited. We also saw that we have a whole colonial legacy of treating forest dwellers as criminals. And Criminal Tribes Act 1861, which was classified several tribes as habitual criminals. I think the same mindset now also is continuing. We have seen that in Orissa, we have seen that in Manipur, we have seen that in so many tribal areas. Anytime they fight for their basic rights, there is a tremendous suppression and also dehumanization of the community. In fact, Dr. Saumya has been part of several such investigation committees in Orissa and Chhattisgarh. Article 46 of the Constitution of India mandates the state to promote educational and economic interests of scheduled caste and scheduled tribes and protect them from social injustice and also exploitation. But it has mostly largely remained on paper, and lot of ground level work is happening because of this community-based organizations and NGOs. Now, access to legal service, we had a special session by Dr. Shalu Nigam on Legal Service Act 1987, and that operates at a national level, at a district level, at the legal service authorities have two roles to perform: legal awareness and also intervention when when any episode takes place or where the person is not able to access justice on its own because of the marginality. Now, religion-based intersectional vulnerabilities is a very, very mind-boggling issues which both state and civil society is facing with more and more majoritarianism. And I think Mr. Sandeep Chachra's lecture very in detail also found out that how caste and religion play a very important role. While Article 29 protects the interest of minorities by making provision that any citizen or section of citizen having any distinct language or script or culture have the right to conserve the same. And they also talk about the provision of financial, social, academic development of minority communities like Muslim, Sikh, Christian, Jain, Buddhist, and Parsi communities. So that is there. And we have certain schemes also, Pradhan Mantri Jan Vikas Karikram, or we have a Minorities Commission had given so many this thing, and we also have a Ministry of Minority Affairs, but increasingly their budget is getting reduced, and that is a major, and the scholarships and opportunities for enterprise development, the allocations have been very measly amount as given, and the organizations are fighting for their rights. Now, coming to intersectional vulnerabilities of persons with physical disability. So we have a law which talks about the right of equality, dignity, and respect for integrity in the Rights of Persons with Disability Act 2006. And we also have several schemes for like the Deen Dayal Upadhyay rehabilitation scheme to promote voluntary action for persons with disability. Or we also have a Rights of Persons with Disability Act 2016, but we can see the exclusion of the person with physical disability is still a mind-boggling issue, because state is doing something, but the private sector or the more support structures and systems are not created. Now, intersectional vulnerabilities of mental health challenge, it's a very important concern which we have now accepted in the post-COVID, post-pandemic era. First time Union government has allocated budget to deal with the mental health difficulties, some of the extremely obnoxious and objectionable terminologies, they have been replaced, and this whole classifying people with mental distress into certain categories, that is also, and putting them into boxes, and institutionalization and biomedical approach, they have been critiqued. And Mental Health Act 2017 provides for mental health care and service for persons with mental illness, and to protect, promote, and fulfill rights of such persons during delivery of mental health care and also services, and for matters connected with the institutionalization. And we have seen so many tragedies that took place in Tamil Nadu, where people were chained in the mental hospital when the fire took place. So many people died because they were chained. After that, more awareness has come. Plus, the question of mental health condition due to gender or sexual orientation or religious vulnerability, cultural vulnerability, caste-based vulnerability. About that also, more awareness is required, and that's why the efforts are being made to fight against the myths about the mental health. Now, coming to the last, very important, the age-based intersectional vulnerabilities. So we have whether you are children, so we have for children also face discrimination. So vulnerable children are identified as being at a greater risk of experiencing physical, emotional harm, or even the risk of, because of the domestic situation, domestic violence, alcoholism, substance abuse. So we have, for children, we have a Juvenile Justice Care and Protection Act 2000, which was amended in 2015. We have a Prohibition of Child Marriage Act 2006. Again, there is recently we had, like during the pandemic, became a major concern because child marriages increase exponentially. And we brought certain age at marriage, whether it should be 18 or 21, and it should be the same for both boy and girl, man and woman. That has been debated. Protection of children from sexual offense Act, POCSO Act was put in place in 2012, and Child Labor Prohibition Act 1986. Still, it is grossly violated. So the 6 key safeguard principles when it comes to children's right as empowerment, protection, prevention, proportionality, and also partnership and accountability. So that is very important. Another section within the age-based intersectional vulnerability is that of elderly people, and their Senior Citizens Act. We had a first Maintenance and Welfare of Parents and Senior Citizen Act 2017. And after the way Professor Latika D was being treated by her cook and by one police officer, it became a big campaign, and we got Senior Citizens Act 2011. And also, so it became a very comprehensive act where the personal care, medical management, nutrition, meal support, mobility and transport, healthcare, money management, social interaction opportunities such as Nana Nani Park, Dada Dadi Park, or community centers, and safety and security, and also the helpline, whether it is a police helpline 1090 or the Senior National Helpline 14567. They are toll-free numbers where senior citizens can approach the authorities when they face any time of discrimination or violence. So what we need when it comes to social security, social protection, and affirmative action, top-down approaches are also important because we need laws and policies by the state, and we also need pressure from below. So you can see that over the last 40 years, how whether it's a tribal organizations or Dalit organizations or transgender people organizations or the LGBT organization, workers organization, farmers organizations, elderly people's organizations or child rights groups or person with disability, all of them have got mobilized, they have articulated their demands, and they have also supported each other. So these are some of the empowering experiences. And the policies and legal reforms, there are 2 routes. One is a legislative route where you mobilize and lobby with the elected representatives in the local self-government body, in the state government, and in the union government and the parliament, and you bring progressive laws. And another route is that of a judicial route, as Dr. Shalu Nigam quoted Justice Bhagwati, that judicial activism has played a very important role during 80s and 90s. So both the routes we need to approach, and also the D.Y. Chandrachudi also said that why it is important that judges also need to behave. They have to be very, very sensitive to the causes of the marginalized community. These are the references I have used, and all of them are easily downloadable. They all are in public domain. Works of Revia Agnes, my articles, Anaga Sarpota's voluminous work on sexual harassment, and Saumya Uma's comprehensive book, Unpackaging Human Rights Concepts, Campaigns, and Concerns. They are all in public domain. They can be referred freely and easily. Thank you very much.
Thank you, ma'am, for providing such a comprehensive and enlightening session. Now, I'm delighted to invite Professor Saumya Umaji for her session on valedictory session implementing gender justice. Over to you, ma'am.
Thank you. Let me just share screen. Okay, thank you to the organizers for having me here. I hope I'm audible.
Yes, ma'am, you are audible.
Okay, okay. So I'm actually, in a sense, going to continue the conversation from where Professor Vibhuti Patel has left, because in her talk on affirmative action, she emphasized quite a bit on the role of the judiciary. And I'm going to continue that conversation and after some initial discussion on gender justice and the concept of gender justice, I'm actually going to focus on a few landmark judgments and have a deeper understanding of how judgments can implement gender justice. Judgments after my initial discussion. So this is the synopsis of what I'm going to talk. What's the time available to me? Can anyone tell me? It's 6:54 right now. Till what time can I continue with my presentation?
Ma'am, around 7:20 or so.
Okay, up to 7:20 and
10-15 minutes for discussion. Yeah.
Okay, fine. Okay. So we will start with a little bit of a discussion on what do we mean by gender justice. Even though we have been, I'm sure, over a period of several days and several sessions, we have been discussing gender justice, but sometimes it's good to go back to the basics, good to go back to the foundations and refresh our memory. So we will start with understanding what we mean by gender justice. What is the relationship between gender equality and gender justice? Because both these terms are used quite often, and quite often we use them in similar contexts. So we will try and get some clarity on that. Then we will move on to gender justice through the law. So what are the ways in which gender justice can be achieved, can be implemented through the law? And then we move on to landmark judgments. Of course, there are many, many landmark judgments. I had a very difficult time in, in zeroing in on a few landmark judgments. But I'm sure Professor Vibhuti Patel has also discussed landmark judgments. Other sessions also you have discussed. And in fact, one of the readings that I've given you, it discusses 14 to 15 landmark judgments. So I think, overall, then you will have a broader sense, more than what I will be able to discuss in the given time. So first, let's start with what do we understand by gender justice? How do we understand gender justice? So one aspect is that it is about substantive equality. What do we mean by substantive equality? A formal equality would be, you know,
I think there is some network issues.
Yes.
Yeah, I think.
Priyanka,
Network issues. Maybe they
Priyanka, take ma'am's screen.
Yes, sir.
Yeah, she's joining. She has joined. Dr. Professor Saumya has joined. Yeah.
Yeah, I'm sorry, there was an internet connection issue.
Yeah.
Okay.
So
we are sharing the screen. We are sharing the screen so that you can.
Okay, fine.
Right. You can see next we will change.
Move on. Oops. I'm not sure what I did. Can you please share again? Or should I?
No, we can share. Priyanka, share again.
Okay, next. Can you please move on to the next? Press again. And again. And again. Thank you. Okay. So, so I was talking about substantive equality. So when we talk about substantive equality and we say gender justice, between whom? Very often we think that gender justice is only about women's rights. And we equate gender justice with equality for women. But actually, gender justice is about equality between, substantive equality between men, women, trans persons, queer persons, the entire LGBTQIA plus community, and so on. And this substantive equality that we talk about is in all spheres of life. So all spheres meaning physical, emotional, intellectual, spiritual. When we say spiritual, we are also talking about places of worship. When we say intellectual, we are talking about places of work. We are also talking about educational institutions, for example. And when we say physical, we are also talking about public spaces. So in all spheres of life, we are talking about substantive equality among all genders. And what should this result in? It should result in jointly and on an equal basis, shaping laws, policies, programs, structures, and decisions. So it is not cisgendered men taking decisions on behalf of women imagining what women's needs would be or what trans persons' experiences would be, but the people who are affected must be involved in shaping the law, shaping the policies, shaping the programs. And these are laws, policies, programs which affect their lives as well as society at large. And this particular definition that I've broken down is something that I've adapted from Oxfam's definition of gender justice. Next, please. Now, very often we talk about gender equality and we talk about gender justice. So how are these two concepts linked? So when we talk about gender equality, we are talking about equal enjoyment, equal access to rights, opportunities for all genders. That is what we are talking about. And when we are talking about gender justice, we are talking about full realization and opportunities for all genders. Can you please click again and again? Yes, thanks. So gender equality in that sense is the means and the end goal is gender justice. So gender equality is the vehicle towards gender justice. Next, please. Now, implementing gender justice through the law, there are many ways. When we say law, law is very broad. And I've tried to break it down through this particular slide. So when we say law, how can we implement gender justice through the law? So one aspect is international human rights conventions and standards. These are particularly conventions that India is a state party to. India has ratified. So the Indian government has an obligation to follow these standards, implement these standards. One of these key standards is in CEDAW, which is the UN Convention on Elimination of Discrimination Against Women, which many of you would be familiar with. But there are other conventions like, Child Rights Convention, Convention Against Torture, Convention on Enforced Disappearances, International Covenant on Civil and Political Rights, International Covenant on Economic, Social, Cultural Rights, and so on. So these set certain standards, and by implementing those standards, domesticating those standards within our country, we are also implementing gender justice. Second is through the Indian Constitution, statutes, particularly I'm talking here about special legislations and also statutory provisions. So in particular, Article 14, 15, 19, 21 of the Indian Constitution, which has already been discussed. When I'm talking about special statutes, I'm talking about the Domestic Violence Act, Sexual Harassment at Workplace Act. These are some examples. And statutory provisions like Section 125 CRPC. Now we don't have the CRPC, we have BNSS, but a similar provision which is on maintenance, or Section 498A IPC, which is now BNS, and that deals with intimate partner violence. So those are provisions as well. Third aspect is on procedural and evidentiary standards, because it is, while we may have very good substantive law, we may have a lot of rights which are given within the statutes themselves, unless the procedures are clear, unless the evidentiary standards are promoting gender justice, it may be difficult. For example, what are the procedures for filing a complaint when there is a rape that takes place or sexual harassment that takes place? Or what are the evidentiary standards that are required when there is physical cruelty against a woman within her matrimonial home? So these evidentiary standards and procedural aspects are very, very important, and they actually determine the extent to which the substantive rights can actually be accessed by the woman. The fourth aspect is judgments. And these include individual judgments, both civil and criminal, as well as public interest litigation. And, although there's a lot of focus on High Court and Supreme Court jurisprudence, that is important case law, important judgments which have been delivered by the Supreme Court and the High Courts, we must remember that very often the bulk of case law is actually in the trial courts, in the district courts, because that's where it is at that lowest level that maximum number of women are able to access the courts. As we go higher up the court hierarchy, lesser and lesser women can access it because of the distance involved, because of lack of resources, and so on. So judgments as a whole are one tool for implementing gender justice as well through the law. Then we have the whole aspect of institutions. Can you please click again? Yeah. So I've listed some of the institutions here. You can see it's quite a big number of institutions. So police, armed forces, judiciary, educational institutions, religious institutions, medical institutions, human rights institutions like the National Commission for Women, State Commissions for Women, National Human Rights Commission. So all of these are human rights institutions, political institutions, media. So all of these would encompass institutions, and implementing gender justice is also through these institutions. So it is important for us to engage with these institutions and to ensure that these institutions are functioning in a smooth manner, without corruption, without bias, without any kind of bias against women, against oppressed castes, oppressed classes, and so. The last aspect that I'm highlighting here are programs and policies. So programs and policies also are related to the law, and here too, gender justice can be implemented through these programs and policies. For example, relief packages. Whenever there is an earthquake, there is a national disaster, and there is a relief package, Chief Minister's relief package or Prime Minister's relief package that is given. Very often these relief packages keep in mind an average Indian man. They do not take into account women, adolescent girls, lactating mothers, pregnant women. They do not take into consideration these categories of women who have very, very different needs. So it is important when we are talking about gender justice that we engage with the programs, policies, such as relief packages. Another example is rehabilitation. Whenever there is construction of housing, which is done, if there is a demolition in one place and there is rehabilitation, there are new houses which are built in another place. Invariably, those houses are in the names of the husband, instead of on the joint names. So this is another aspect of gender justice which is related to the law, related to the rules, regulations, schemes, programs, policies, and so on. Even during COVID and the entire lockdown period, we saw how initially many of the policies were not really geared towards women, and women with very, very specific needs. For example, physically challenged women, mentally challenged women who are in the house, or trans women, or lesbian women, who were facing very, very specific kinds of violence and threat to their lives. But the policies at that time initially were not geared towards that, and it needed to be voiced out, and there needed to be advocacy to get these policies to address the specific experiences of various genders. Next, please. Yeah. So now we move on to some landmark judgments on gender justice and the Indian Constitution. I've taken Indian Constitution, particularly because otherwise, if we look at specific statutes, there are many under Domestic Violence Act, many landmark judgments, under Sexual Harassment at Workplace Act, again, many landmark judgments. But just by way of understanding how the constitutional provisions can be applied to further gender justice, there are 5 judgments that I would like to talk about. It's I'm at 7:12 now, so in about 8 minutes, I will try and talk about these 5 judgments. The first set of judgments that I want to briefly talk about is anti-gender stereotyping. This is a principle which was laid down in Anuj Garg judgment, and it was later applied in Navtej Johar judgment as well. Second is on right to dignity and bodily autonomy, where I will discuss Joseph Shine. Third is on right to choice in marriage, where I will discuss Shafin Jahan judgment, which is popularly known as the Hadia case. The fourth aspect will be rights of trans persons, where I will briefly touch upon the Nalsa judgment as well as Arun Kumar's judgment. And finally, the marriage equality aspect, where I will discuss Supriyo judgment, which is one of the latest judgments that we have had. Next, please. So let's start with the anti-gender stereotyping principle, which was laid down in Anuj Garg versus Patel Association in 2008. Next, please. No, I think, yeah, okay. So this particular case concerned a challenge to constitutional validity of Section 30 in the Punjab Excise Act. And this particular section prohibited the employment of any man under the age of 25 and any woman in any part of an establishment in which liquor or another intoxicating drug was being consumed. So this was a pre-constitutional legislation. It was passed before the constitution came in. So before Article 1415 became law of the land, and it was automatically just adopted without an application of mind. And this particular provision, Section 30, was challenged. And the argument in defense of Section 30 was that this section was important to ensure the security of women. And what the Supreme Court said was that the present law ends up victimizing its subject in the name of protection. And it suffers from incurable fixations of gender stereotyped morality and conception of sexual rule. Next, please. It said that it is the state's duty to ensure circumstances of safety, which inspire the confidence of women to discharge the duty freely, but any other policy interference such as Section 30 would be oppressive to women and against their privacy rights. So there was, we can say that this particular judgment, the section which came into challenge, that was actually a kind of romantic paternalism. It was about control over women's sexuality, which is a key patriarchal assumption. It is deeply, deeply entrenched in law. There is protectionism, so it is protecting all women. So you can see in many of these laws, either women are looked at as seductive sexual objects, or they are looked at as hapless victims. These are the only 2 categories where in the eyes of law, this is how women are perceived. And this particular Anuj Garg judgment is very important because it laid down that gender stereotyping is anti-constitution. So ultra vires the constitution. Next, please. So what we see is that this particular anti-gender stereotyping principle was further developed in Navtej Singh Johar versus Union of India, which was a 2018 judgment of the Supreme Court. This was the judgment in which Section 377 of the IPC, the infamous Section 377, was actually read down with regard to consenting adults having sexual intercourse. So in this particular case, the Supreme Court said that a criminal provision that has sanctioned discrimination grounded on stereotypes imposed on an entire class of persons on grounds prohibited by the article, and this constitutes discrimination on the grounds only of sex. So what it also that it Section 377 through Section 377, the state perpetuated social stereotypes and it encouraged discrimination against gays, lesbians, bisexuals, transgender people, and so on. So we see how this important principle of not succumbing to gender stereotyping, how that came to be applied in a subsequent judgment. Next, please. Next, I'm going to talk very briefly about dignity and bodily autonomy, where Joseph Shine versus Union of India 2018 judgment, this upheld the dignity and bodily autonomy of women. Next, please. This particular judgment related to Section 497 of IPC, which was a provision on adultery. And as per this provision, the wife, if a man had a sexual intercourse with another person who was the wife of another man without the consent or connivance of that man, then such sexual intercourse, even if it did not amount to rape, that means even if it was consensual on the part of the woman, even then that man would be held guilty of the offense of adultery. Next, please. So the ramifications of Section 497 were many. First was that the criminal provision was attracted when a man had sexual intercourse with a married woman only. So why married woman? Because the married woman was considered the property of her husband. It was applicable only where the sexual intercourse was without the connivance or the consent of the husband. So if the husband was okay with it, or if the husband connived, then it was, this particular provision was not applicable. And third aspect was that sexual intercourse should not amount to rape, because if it amounted to rape, then there was another provision, which was the offense of rape, that would be attracted. And primarily, it was the husband who was considered the aggrieved person, and only he could complain against this other man who invaded into his property, which is his wife. The punishment is prescribed only to the man who had sexual intercourse, and neither the husband nor the wife could initiate criminal proceedings against each other. Next, please. So in this particular judgment, the Supreme Court broke new ground. Before Joseph Shine judgment, there were other judgments which upheld the constitutional validity of this section, saying that, oh, it protects women, and women are very often victims, and they are seduced, they are, married women need to be protected, and so on. But in this particular judgment, the Supreme Court gave primacy to women's bodily autonomy, dignity, privacy, sexuality, sexual agency, and individual choice. And it again said that these were, the provision actually contained a lot of gender stereotypes, which violated the dignity of women. person are absolutely and manifestly arbitrary and doesn't appear rational at all. And this was violative of the of Article 14. Next, please. Next, we move on to Shafin Jahan versus Ashokan. This is on right to choice in marriage. I'm sure we are all aware of Hadia's case. Next, please. So I'm not going to get into the facts, but basically Hadia was a Hindu woman originally. She converted to Islam. She married a Muslim man. And her father petitioned the court saying that she was lured, she was forcibly converted, and so on. It's important to remember that she was 24 years old. So she was not a 12 or 15 or 16-year-old. She was 24 years old. And yet the Kerala High Court judgment refers to her as girl. In every place, it refers to her only by her Hindu name. Although she had voluntarily converted to Islam, it uses her Hindu name and it refers to her as girl. And the Kerala High Court had actually annulled the marriage and it sent Hadia back to her parents' custody. And it said that a girl aged 24 is weak and vulnerable, capable of being exploited in many ways. Husband petitioned in the Supreme Court, and the Supreme Court's final judgment acknowledged Hadia's right to choice in marriage and to religious conversion, and it set aside the annulment order and it released her to live with her husband. Next, please. So this particular case, it was posed as if it was a conflict between national security and a person's liberty, because the argument made was that he had married her and he was going to take her to Syria to join ISIS. But it was always about agency of a young woman. A young woman who is a major, does she have the right to choose her partner? Does she have the right to choose her religion? And in both issues, the court said yes, she does have the right, and denial of adulthood and agency of young women was something that the Supreme Court was against. Next, please. I've just reproduced some of the quotes from the judgment, and it said that the right to marry a person of one's choice is integral to Article 21 of the Constitution, which is right to life, and that intimacies of marriage, including the choices which individuals make, whether or not to marry, whom to marry, lie outside the control of anyone, and courts as upholders of constitutional freedoms must safeguard these freedoms. So this is what the Supreme Court said. Next, please. So now I'll move on to rights of trans persons, and there are two judgments, Nalsa versus Union of India and Arun Kumar versus Inspector General of Registration. Nalsa judgment, I think Professor Vibhuti has discussed, so I'll go very briefly over it only. Next, please. So it declared that hijras and eunuchs, eunuchs is not a desirable word to use at all. Hijras is the word that should be used. Eunuchs is a very derogatory term which was used by the colonialists. But some of the judgments have used this term. What Nalsa said was that they can be legally identified as third gender. And there was a direction to constitutionally and legally recognize trans persons as the third gender, persons who are outside of the male-female gender binary. And fundamentally, equally to the third gender in the same way that it is available for everybody else. And the court also emphasized that the need of civil laws to be made trans-inclusive. And it acknowledged the hurdles that transgender persons face in exercising many rights, including inheritance and so on. Next, please. No, I think you skipped. Yeah. Okay, so Transgender Persons Protection of Rights Act came after the Nalsa judgment, and it recognized identity. It provided rights and entitlements. It also provides for offenses and penalties. So it prescribes punishments for certain kinds of offenses. One of the concerns, and this is something in my writing that I've consistently highlighted, is that if there are sexual offenses, physical offenses, attacks against trans persons, the punishments which are prescribed in this act are much, much less than what it is in the Indian Penal Code. So although it provides for offenses and penalties, it still does not treat transgender persons on the same, the offenses against them are not treated with equal seriousness as offenses against women or offenses against other people. Next, please. Arun Kumar versus Inspector General of Registration is an important judgment. And in this judgment, the issue was whether the term bride, which is mentioned in Section 5 of the Hindu Marriage Act, did it mean only a cisgendered woman, or did it mean a transgender woman as well? And the court relied on the Nalsa judgment. It also relied on Navtej Singh Johar judgment, Justice Puttaswamy judgment, which talked about right of privacy. And it said that this is a Madras High Court judgment, and it said that the expression bride in the Hindu Marriage Act cannot have a static meaning, and it included trans women to be within the definition of bride. And this particular judgment was upheld by the Supreme Court in Supriyo versus Union of India. Next, please. So this is the last judgment that I'm going to highlight, Supriyo versus Union of India in 2023. There were many issues involved. I'm just going to briefly, next please. I'm going to briefly talk about, touch on some of the aspects that the judgment said. So unanimously, the court, there were 5 judges in the bench, and they said that there was no fundamental right to marry among queer people. Transgender persons in heterosexual relationships have the right to marry given the existing legal framework. But as far as queer people are concerned, so when we are talking about same-sex marriages, in this particular judgment, it has not held that same-sex marriages are legal. That hasn't happened. But what the majority of 3 judges said was that the issue lay exclusively in the domain of the legislature. So it is up to the legislature to enact a law on this. Next, please. So I've just given certain excerpts, and I want to use these excerpts to show that all is not lost, even though same-sex marriages have not been legally recognized. Of course, after that, there are subsequent attempts to go to the Supreme Court through, through a curative petition, through a review petition, and so on. The state must enable the LGBTQI plus community to exercise its rights under the Constitution. Queer persons have the right to freedom from coercion from their natal families, agencies of the state, including the police and other persons. license. So this is something that the Supreme Court said. And this last quote on the right side, this is also an important one, which says that recognition of I'm sorry, I'm not able to see this very clearly. One second. Legal recognition of non-heterosexual unions represents a step forward towards marriage equality. At the same time, marriage is not an end in itself. Our constitution contemplates a holistic understanding of equality, which applies to all spheres of life. So this is again something that the Supreme Court judgment said. Next, please. This is my last slide. And based on what I have discussed so far, I want to conclude that these judgments which I've discussed, these are representative, they are not exhaustive, and that gender justice through the courts is only one approach, and it is not the only approach. Initiatives through initiatives towards gender justice through the law will remain ongoing. For example, there are now that the 3 criminal laws have come into force. There are attempts to look at these criminal laws through a gender justice lens. Just about a week or 2 ago, I had written an article in The Wire looking at the criminal laws through the gender justice lens. So I'm sure a lot of people are talking about it and writing about it as well. Law is, of course, not the only tool to achieve gender justice. Although we are taught the law in, for 5 years in the law school, and we tend to think that, law is the solution to everything, but it is, of course, social, economic processes, political processes, which are equally important. And what helps in terms of implementing gender justice will actually be a multi-pronged approach. With that, I end the presentation. And any questions, we can have a discussion.
You are muted, Ritika ji.
Sorry. Thank you, ma'am, for providing such a comprehensive and enlightening session. Now, we invite Professor Vibhuti Patel ji for her remarks.
Yeah, I think both of us have complimented each other. So Professor Saumya and myself. The dilemma that we have been facing in the last 75 years is that we always say constitution was much ahead of time. And even Baba Sahib said that we have come up with the best constitution, but the reality is very different. But when it comes to same-sex marriage, it is reverse. Because if you see all around, people are supporting. Parents are supporting. Sometimes friends are supporting. Sometimes employers are this. But the judgment has been so regressive. And also the more than 200 IAS officers and retired judges and all, they wrote an open letter, and the kind of pressure they created when the judgment was going on. So how do you see this kind of, do you think elite is more conservative than the masses?
That's a good question. I think, judgments, if when I had panel discussions on the Supreme judgment with queer and trans people who were involved in the entire initiative itself, they didn't have much hope that the Supreme Court will actually go for, legalizing same-sex marriages. They think that it is going to be a long-drawn struggle, and it's going to be an incremental one. But definitely they are not going back. It's not it's not as if those who have come out of the closet are now going to go back into the closet. So because of Navtej Singh Johar judgment, because of so many other judgments, there has been a certain amount of acceptability. I think when it comes to the judiciary, there are many, many considerations. Some of them may be legal considerations. Some of them may also be extraneous considerations. Sometimes the judiciary is also concerned about what is going to be the response of the people. So who is this people? If the parents are supporting, if the friends are supporting, if the immediate community is supporting, then who are these abstract people that one needs to cow down to? So I agree with you that the superior judgment has not been as positive as one should be. It should have been, and let's hope that the Supreme Court finds an opportunity to actually correct itself, because otherwise it would have been a historic judgment, not only for India, but for entire South Asia and Asia. It would have been a judgment which would have been referred to in the queer movements and the trans movements all over Asia. But it was
so many Asian countries are ahead of us, no? It is only in Africa that homosexuality has been outlawed.
And Nepal particularly has been much ahead, and actually we should be borrowing or taking inspiration from the laws and the legal developments in Nepal.
And also Thailand, no? Thailand.
Yes.
Yeah. I just want to ask one more question, is about the Nanavati case. That was also a case of adultery, and where right from Prime Minister and President, there was so much sympathy for the murderer. And now we have reached a stage where we are some of the problem. How do you see this journey of women being property of a husband in the Indian context? No.
Yes, I think the adultery judgment, the Joseph Schein judgment, was part of a success. I'm saying it is part because the law continues to have provisions which treat the married woman as the husband's property. For example, the marital rape exception has not, from the offense of rape, there is an exception for marital rape. So if a husband rapes his wife, that does not amount to rape. Why? Because the wife is considered his property, and she is considered to have given consent, a blanket consent to sexual intercourse upon marrying him. So that provision continues to exist. Similarly, there is another provision which is, even though adultery has been struck down from the criminal law, so the new criminal law, that is the BNS, does not have the provision on adultery, but it has retained another provision which talks about enticing and seducing a married woman. So, to me, it appears like it is adultery which is reintroduced through the back door. So that also considers why this fixation on married women, why this fixation on, and why is it when we talk about criminal law, we are talking about state interference, right? So why is it a legitimate interest of the state when a man entices, seduces, or consensually has sexual relationship with a married woman? It can go in for a matrimonial remedy. Why is it a legitimate interest of the state for using the criminal law machinery? I think that's a question that we really
are like a square one, no? The same Nanavati case mentality. Yes, come up with this new law, no?
Yes.
Thank you. It was a brilliant session.
Thank you.
Thank you, ma'am. We at IMPRI hope you continue to collaborate with us in the future as well. Now, I would like to invite Advocate Dr. Shalu Nigamji for legal hands on this session. Over to you, ma'am.
Yeah, hello. Yeah, both these sessions are wonderful and brilliant, and I really don't know now what to present because uh, you know but just one thing I just want to say that why the courts and the law, they generally see women as as wives or as as mothers or as daughters-in-law, but not as citizens. So so there is a lot of gap in the Constitution. 75 years back, we talk about women as citizens, and now again, we're still struggling. For over years, we have just been struggling. Why women are not considered as citizens rather than being wives or daughter-in-law or mothers or whatever. So so what should we do as a women's movement or as lawyers or as um, judges, what should be done in that situation? So this is just I want to raise. So and thanks for wonderful presentation. So I really don't know if how much time I have, because I have a lot of presentations. So we can talk about domestic violence law, we can talk about various other laws, but I really don't know how much time I have, because I think we have to go for the team presentations. So
yeah. No, ma'am. We called you for your comments on Professor Patel and Professor Uma.
Yeah, those were wonderful
can-
presentations. It's kind of a capsule that we have just presented a lot of things. So, so thank you for
Q&As.
Yeah.
Now we open the floor for participants to ask the question on both the sessions. They can either raise their hand or type their queries in the question and answer box.
I think they are more interested in sharing their work, the presentation. Yeah, we had one presentation last time, so remaining is the.
Okay. So anyone with any questions?
Would you like to share your creative presentation? Who would like to go ahead this time?
So now we are moving on to participants' creative project presentation. Participants are requested to kindly raise their hands so we can move in an orderly manner.
Mr. Ashan Jamil, are you ready? Hello. Khushbu,
Hello.
Khushbu has raised hand. Yeah. Are you ready? I said. So
yeah, ma'am. I'm kind of ready. I couldn't give like much time to the presentation because I'm a working professional, and
yeah,
I have been like relatively more busy in the last 2 weeks. But let me join. I'm joined with through the mobile. Let me join with my laptop so that I can give the presentation.
No, I think Khushbuji has right. Khushbuji, you can go ahead. Hello.
Yes, am I audible?
Yeah.
Okay. Yeah, I'm presenting my topic on new tourism for environmental justice and social sustainability. First, would like to explain the terms mentioned in the topic, the new tourism for environmental justice and social sustainability. New tourism, also known as responsible tourism or sustainable tourism, and it refers to a modern approach to travel that emphasizes on minimizing the negative impacts of environment, culture, and society of the destination visited. it seeks to promote ethical and sustainable practices in tourism practices. Main focus area is environmental sustainability. Second is cultural respect, in which they aim at preserving and respecting the local culture, traditions, and heritage, and ensure that that the tourism contributes to the cultural exchange and understand rather than they exploit the tourist products. There's also economic benefits of creating jobs for local communities and business for local communities. The other aspect and focus is social equity. It promotes inclusiveness and equity, ensuring that tourism benefits are fairly distributed amongst all the stakeholders, including the marginalized and disadvantaged groups. Another focus area is community involvement. It also helps in engaging the local community in tourism planning and decision making, and ensures that their voice are also heard and get a more responsible and balanced experience between both tourists and also the host community.
Yeah, your slide is not moving, Khushbuji.
Ma'am, I'm only describing the topic, the terms first, and then I'll come back to the slides again.
Okay.
We're talking about environmental justice. Previously, we already had a session on this. Environmental justice is a fair treatment and meaningful involvement of all the people, regardless of race, color, national origin, or income, in development, implementations, and enforcement of environmental laws, regulation, and policies. It also seeks to ensure that no group of people, particularly marginalized or disadvantaged communities, bear a disproportionate share of negative environmental consequences resulting from industrial, government, and commercial operations. The third and important aspect of this topic is social sustainability, which refers to the ability of a society to maintain and improve the well-being of its current and future members. It also involves creating an equitable and inclusive environment that supports human rights, social justice, and fair access to resources and opportunity. Social sustainability focuses on all the aspects, including education, healthcare, employment, housing, community cohesion, aiming to foster a social capital and resilience in the face of challenges and changes. Tourism development and environmental sustainability. Tourism development has both socioeconomic advantages and adverse environmental effects. It stimulates travel, exploration, and interaction with natures and cultures and societies. However, it can lead to environmental degradation due to factors like land overutilization, pollution, and intrusion from external cultures. Balancing the business and the environment. A sustainable ecotourism framework aims to balance business interests with environmental conservation. Government supports a policy interventions plays a moderating role in maintaining the ecological systems. What are the socio-economic benefits? It provides employment, business opportunities, and infrastructural growth. However, the state of natural and environmental capital may degrade over time. What are social vulnerabilities? There's overutilization of the land, there's traffic congestion, solid waste accumulation, pollution affecting the social environment. Local communities may face challenges due to these impacts. These photographs have been taken from my field study. I'm also incorporating the review of literature, where it says the tourism is an industry which uses the host community as a resource to sell its product, and in the process also affect the lives of everyone. Here, the person is being impacted by the foreign tourist influx, the pattern of his dressing up and the food and everything is being impacted. This is also a picture from my field study, where we also say that tourism is product that relies totally upon the simultaneous production and consumption.
Khushbuji, your slides are not moving. You can, since it's Word, you can.
It's moving?
It's not moving. You can stop the share and then try sharing again.
Okay, sure. Is it visible now?
But we cannot see the full screen. You can continue on working mode only.
But in my place it is showing full screen.
Yeah, but we cannot see.
Which slide are you saying? Community-based tourism?
No, we are on just the first slide.
Oh.
No, you stop share and then share again, and then don't go full screen.
Why is it happening again?
That happens sometimes. No issues.
Is it visible now?
Yes. Now keep changing slides from here only.
Okay. Is it visible now?
Yes.
Okay. According to Shalu, it is difficult to define the term community precisely. Nevertheless, the word can be used to refer the group of people who exist in one particular location. Host societies are in fact communities made of community is defined as a group of people who share common goals or opinions. Here, all those who live within the tourist destinations have common goals, and they are whether they are homogeneous or heterogeneous, regardless of whether the impact of tourism are beneficial or otherwise, they all have common motives and common goals. There's community-based tourism, where there's a shift towards the in which the local communities is actively involved in planning and participation. Reversing community for the contribution to the land ensures more equitable practices. There are ethical dimensions in tourism, which considers impacts on local communities, the environment, and also the cultural heritage. Sustainable development should prioritize social justice and participation in also the political processes. By integrating environmental justice, social sustainability, and community involvement, we can create more balanced and responsible approach to tourism that benefits both people and the planet. There's a case study on ecotourism in Costa Rica. I'm just referring to this, and I've also taken the screen. The screen has vanished again. Is it visible again?
No, it's not visible.
Yes, and don't go full screen. Don't go full screen. Don't go full screen.
Okay.
फिर से stop and share again.
Shall I stop and again share?
Yes.
Is it showing?
Yes, आप full screen मत जाइए. हाँ, यहीं से change करिए. Yes.
अच्छा ठीक है. Yeah, there's a case study of ecotourism in Costa Rica, where which aims to balance environmental conservation. The ecotourism aims at balancing the environmental conservation, economic development, and social equity. Since it is rich in its biodiversity, over 25% of its land is designated as protected areas, including the national parks, wildlife refuges, and the biological reserves. Environmental justice in Costa Rica ecotourism sector involves ensuring the local community benefit from the tourism while preserving their natural resources. In this initiative, community is also involved. There are conservation efforts. There's sustainable practices also into play. And there are also certification for sustainable tourism programs established by the Costa Rican Tourism Board that rates businesses based on their environmental impact and sustainable practices. Social sustainability in ecotourism focuses on improving the well-being of local communities, promoting the cultural heritage, and also ensuring equitable and economic opportunities. In Costa Rica, this achievement is through local employment and training. Cultural preservation is being done. Revenue sharing is also being done. So, in a way where profit from ecotourism are often reinvested in community development projects such as school, healthcare, facilities, and infrastructure. This ensures that economic benefit is also imparted along with a community development is also happening. There are challenges to these things also. The first is there's over-tourism. Since these areas are popular destinations, there's overcrowding and there are also degradation of the local resources. They're balancing development and conservation, ensuring the tourism development, environmental and social goals requires careful planning and regulations. And their government and NGOs work in promoting those sustainable practices. There's economic inequality as well. The efforts to expand community-based tourism projects are being done. Costa Rica demonstrate how tourism can be powerful tool for achieving environmental and social goals. I've concluded the thing that new tourism are environmentally sensitive and respectful towards the culture of the host and learn from experiences at the destination. There are no more inactive guests who are mere spectators. They equally participate in the activities involved at tourist destination. They resort to sustainable tourist practices that are economically viable and socially responsible. Tourism often brings environmental degradation, and new tourism tries to overcome such challenges. New tourism aims at engaging both tourists and also the host community to promote sustainability. It seeks ensures that technology and measures used are environmentally sounder, and the need for more experienced tourists, use of ecological materials, installations of new renewable energy sources, etc., are some issues being addressed in this new kind of tourism. And in my case, I'm focusing on a case study on the area I studied, which is Rishikesh. So I'll give in the way Costa Rica case study has been done. So I'll be enlisting the some of the key points on that in my essay.
So you are coming out with a research paper, huh?
Yes.
Thank you. Good.
Thank you, Khushbu Datta ji.
Yeah. Thank you.
So Charji, are you ready? Hello.
Hello. I would.
Asha.
Yeah. Yes, ma'am. I'm ready.
Yes. Okay.
Kindly introduce yourself first.
Okay. So, my name. Am I audible? Am I clearly audible?
Yes.
Yeah. So my name is Ehsan, and I am a lawyer, and I did my postgraduate just last year. And after that, after a very brief litigation experience in Delhi, I moved back to Lucknow, and I joined as a legal consultant in State Institute of Rural Development. So the theme of the course, which is like bridging gaps in policy enforcement, it's like true to what I set out to do in the near future. So that's why I've joined the program. So
what are you working on in terms of project?
Sure. So this is my topic of my assignment will be critical reflections on empowerment of women through legal literacy.
Ehsan, you can try going full screen.
Yeah. What are you saying?
Full screen.
Full screen. Try to go full screen. वहीं पे slide show है.
I'm going full screen. Is it visible?
Yes.
Screen is visible, लेकिन full screen नहीं हुआ. ऊपर आप देख रहे हैं ना, home insert, draw design, transition, animation, उसके बगल में ही है slide show. हाँ, उसके right slide show, yeah. From start, सबसे पहला वाला.
Okay.
Yes.
Thank you. So since it's a critical reflection, I want to reflect on what's the problems with the law, particularly law, Saumya ma'am also mentioned in the last session, law is not the only solution. So since independence, various laws have been passed which are designed to protect the interests of women, be it Domestic Violence Act, be it Sexual Harassment at Workplace Act. But the real question is that are these women reaping the benefits of these progressive laws? So the answer is clearly no, because although we are improving as a nation, but still a lot needs to be done. So there is a gap that exists between the formal, there's a gap that exists between the formal equality and the substantive inequality that continues to characterize women's life. Although laws promise equal opportunity and equality in status, but women lack access to effective enforcement mechanism. They are not aware of their rights. They may be facing like social and pressures within their families and communities to make a claim for their rights. And they may lack economic and geographical and even political access to the legal system. And as a result of like cultural and social conditioning, women themselves lay down injunctions that sanction violence against them. For example, the dictum taught by mothers and their mothers-in-law to young girls that a woman's only home is her married home. So there are several reports that showcase that reveal that women are at as much as they are at risk inside their hello.
Yeah.
Yeah, so they are at risk. They are prone to sexual harassment, sexual violence, sexual uh, uh, assault within their homes. Many a times the assailants are normally the people within their family. So are they face backlash by the society and family in reporting their own family members as an assailant, and there are instances of police report not being launched or withdrawal due to pressures by society. So the strategy of like using the discourse of rights in the courts preclude an analysis factors responsible for crimes of such nature. That is the unequal economic relationship between men and women and the patriarchal relationships on which family is based. So what I'm trying to give the present status of legal literacy programs in India. So the National Commission of Women and National Legal Service Authority in 2020 launched a pan-India legal awareness campaign to teach practical information about legal rights and remedies under various women-related legislation. So uh, women and girls are educated on their rights under numerous laws, including penal code, or as a part of this program. Now, in another effort, the NCW has also recently launched an app, which is Her Legal Guide, which focuses on rights and statutes pertaining to women in India. So just with one clip, it is expected to empower women. But we need to critically examine it in the light that how many the gender divide in digital literacy in India. The National Family Health Survey shows that only 50% of women in India have access to smartphones, which they actually use by themselves. So we have to adopt like as you said, an intersectional approach to analyze the problem of gender inequality. The second is the Department of Justice has introduced a scheme on access to justice titled Designing Innovative Solution for Holistic Access to Justice for a period of 5 years from 2021 to 2026. It's a pan-legal legal literacy and awareness program that to enable vulnerable sections of society to have access to information about their rights, entitlements, and creating better legal awareness. So as a part of my assignment, I have filed RTIs to legal Department of Justice, and also to Institute of Public Administration, which is located in Delhi. So as per their website, they have shown that Institution of Public Administration will be evaluating and monitoring all the schemes under Disha, that all the programs that have been running under Disha. So I have asked them that on what parameters are they are they calculating the effectiveness of this program. So that will give me a comprehensive, by the time I'll be able to like shape up the final article, it will give me comprehensive information on like on which I can comment about the effectiveness of the program. As you have seen, the legal literacy is often advocated as a means of realizing the formal rights guaranteed by law. The lack of awareness of these rights is seen as a major factor in the gap between the formal rights of women and other disadvantaged groups, and continuing social and economic inequality of these groups. So according to this approach, the crux of the presentation is this. According to this approach, legal literacy involves educating people about their legal rights so that they will be in a position to enforce these rights. But it is an information giving model. Access to information about right is seen as the first and significant step towards ensuring women access to law. The standard approach is to convey the information about the law through lectures, pamphlets, one-day seminars in which participants are passive and uncritical listeners. So what are the possible solutions? An interactive approach to education must be adopted in which women actively participate in the learning process. There are several NGOs which have been doing such work, but my article will focus on states' responsibility. So what programs are states running and how effective they are. So local women should be encouraged to form a problem-solving or self-help group. Once the group is formed, an attempt should be made to create an environment in which women feel emboldened to discuss their problems and try to solve them through negotiation and legal procedures if required. To achieve this task, women are educated on various legal issues concerning them as divorce, maintenance, property rights, healthcare, rape, sexual harassment. Perhaps the most important outcome of the project, of such approach would be the transformation of rural women from being dependent and vulnerable citizens who are restricted to their homes into confident individuals coming out of their homes and visiting government office, police stations, block panchayat office, and so forth. So working in self-help groups and various committees has also promoted a culture of self-learning, thus enabling women to take up problem-solving roles in the future. So this method will be actually empowering, will empower women. So the putting an end to gender-based discrimination in a country where religion, I can't see what's written. Just give me a minute. Where religion and traditions and social attitudes sanction inequality is an enormously difficult task. And the legal literacy programs must also include changing both women and men's attitude to human rights and gender equality. Sensitization of society through every means available regarding gender equality and women empowerment would greatly help in humanizing modern Indian society. The solution lies in educating children from an early age. In this context, another alternative method could be like community awareness against sexual discriminations can be achieved by involving basic workers at grassroots level. So such workers can spread the message more effectively as their acceptance at the community level is very good. Anganwadi workers are important in this context of providing knowledge through integrated child development service program. They can be seen as a vital change mediators in elimination of girl-child discrimination prevalent in the society. The spectrum of services at the Anganwadi Center, including supplementary nutrition, basic healthcare, and preschool education, offers a unique opportunity to address for spreading awareness against gender discrimination. So, at last, I want to conclude by quoting the words of Justice D.Y. Chandrachud. So, according to him, the legal concept of women's rights is not only a woman concern. Awareness is not only a woman's issue. Awareness about rights of women can be truly meaningful if that awareness is creating amongst the younger generation of men in our society, because I believe that the deprivation of rights of women, if we have to find an answer to them, the origin must be in the changing of mindset, both of men and women. The more we realize that the category of women encompasses various social, economic, and political disadvantages, the more we will be able to cater to their individualized and actual needs. True freedom for women, in other words, is truly intersectional. So that's it.
Very comprehensive work.
Yeah, in the last, this is the work which I've been doing. I've with NCW, I have conducted some legal literacy programs, but it's just one-day seminar, and I've realized that the inequalities are structural and they have been practiced over ages. So one-day seminar just giving information is not enough.
Very important. On a day-to-day life, it has to be integrated, the efforts.
Yeah.
Thank you, Ehsan Jamil ji.
You can convert it into a research paper, no?
Yes, ma'am. I'm waiting for the responses from the RTI that I have filed. So once they come, then
yeah, that would make add a massive value to your work.
Yeah, so that I can actually like see how effective these programs are.
Can I just give you two points just to think about? The one is that you can also file RTI about how much money NALSA or National Legal Service Authority is spending on legal literacy program, because they have budgets fixed for everything. So you can just find out. It may be there on the website, or you can file RTI for that. Second is about there's a provision when you talk about Anganwadi workers being given this role of conducting legal literacy sessions. There is one scheme called paralegals, which was introduced by NALSA. There was a lot of discussion about it, and some of the NGOs, they've started doing work on that. So maybe just finding out what this paralegal scheme was and where it has reached. Is NALSA doing something on the scheme? So these are just 2 points which you can
also about Nirbhaya Fund, no?
Nirbhaya Fund also.
Since 2013, why there is so much of unutilized fund. If you can have a section on that, because there's so much, it could be used for gender equality purposes. Please unmute yourself. You're muted. Unmute.
Kindly unmute yourself, Ehsan Jamil ji.
So ma'am, I've proposed like one gender sensitization program of Anganwadi, but it's pending because of lack of funds. The proposal is pending since last 3 months, and I have drafted the entire proposal and sent it to NCW on their request only. But after elections, they said we will be able to provide funds only after election, but there is no funds actually. So that's the main problem which I'm facing in running these programs.
But one more proposal you can make on from Nirbhaya Fund also. Or Mission Shakti. Mission Shakti, they are releasing. There's a student of mine. She has joined as a young officer in Ladakh. She sent the proposal. She got the funds also.
Okay.
Gender sensitization fund. She got.
Okay. Thank you, ma'am. Thank you so much.
Thank you, Ehsan Jamil ji. Now we would like to invite Professor Vibhuti Patel ji for her remarks on this presentation.
Yeah, I think the presentation was very comprehensive, and he has also done a major review, and being a legal practitioner also knows the issues on this. But I think budgetary allocation, very important issue, which even Dr. Shalu also said. But it's not only ICDS, because ICDS, the Anganwadi workers are overworked and they have too many things to do. Okay, food and nutrition and awareness and door-to-door services and all. But I think Vibhuti Fund, which is a dedicated fund to deal with gender-based violence, I think that is a massive underutilization. And about that also, there should be proposals should be sent, and also RTI, because why there is such a big variation, why certain states are able to utilize it 30, 40, 50%, which is also not adequate, but there are states after states and union territories where there is a zero utilization. So is it a lack of political will? money is parked in the ministry, why doesn't it get utilized? I think that would add tremendous value to the work which Mr. Ehsan Jamil has done on gender equality through legal literacy.
We
Thank
would
you.
also like
Thank you so
Advocate
much for your
Dr.
remarks.
Shalu Nikamji for her remarks on this presentation.
Yeah, it's a very wonderful presentation. Like, it's a very basic thing, and not many people have, done this kind of survey or research. So basically, your research will do a lot of favor to, the kind of programs and schemes which are going on. So, but basically, just general things like, basically the funding part, and also how much fund is being utilized, because allocation of fund is one aspect, and spending is another aspect, because a lot of times we have heard that even the Nirbhaya fund, a lot of funding has been spent on
only publicity
advertisements and other things, and not on actual programs. So that is one thing which you can also highlight in your presentation. So this is just one small suggestion which I just put.
Thank you so much.
Thank you.
Now we would like Zarna ji to present her creative project.
Hi, good evening. Am I audible?
Yes, you are audible.
Very good evening, Professor Vibhuti Patel, Dr. Shalu Nigam, Ritika ji, and all my fellow IMPRI mates. I'm really happy to share my presentation. My name is Jharna. I'm based out of Ahmedabad. I work with Confederation of Indian Industry as a policy maker, or rather as somebody who deals with policy makers from the industries and the government. And can I share my screen quickly for the presentation?
Yes, you can.
Is my screen visible?
Yes, it's visible.
Okay. So basically, the topic of my research. Just a minute. So the topic of my research presentation, or rather, the abstract and the paper that I'll be submitting is future proofing India, integrating aging population consideration into policy and planning. So while dealing with a lot of policy matters and going through a lot of surveys, existing material, what we've realized is there is a section of society which is the aging population of India, which is often people really miss out on. We don't put much much consideration to this section of society. So because of this, I thought of taking up this project and doing some research on it. So very quickly, I just wanted to start with so basically, we all know that currently India is a young country and it has a young population, and more than 50% of its population is below the age of 25 years. And in the coming years, when we speak of Viksit Bharat at 2047, when we say that India will become a 5 trillion economy in 2047 during its 100th year of independence, we are slowly seeing that India's demographic landscape is undergoing a significant transition. The elderly population is projected to surge, and in the coming years, these trends necessitate a proactive approach to policy and planning. And we must acknowledge the challenges and opportunities presented by this demographic to ensure a future-proof India that caters to all the ages. During this Vibrant Gujarat Global Summit 2024, Niti Aayog, along with BCG and CII, released this document, which was vision document for Viksit Bharat at 2047. This document essentially has two chapters. One is earning well, and another one is living well. So while the earning well chapter necessarily talks about industrial development, economic development, The Living Well chapter talks about social and educational development. But while this economic development is crucial, ensuring the well-being of our senior citizens is equally important. And we note that there is a gap in reports focus on social and economic aspects of senior living. And this presentation and my research paper will explore the areas where we can bridge this gap and create a more holistic vision for an inclusive India. So here are some quick statistics as far as these reports go. I have cited some existing reports that India has surpassed China as world's most populous country with over 1.43 billion people by mid 2023. The population of 60-year-old is around 153 million, and it is projected to reach a staggering 347 million by 2050. The median age is expected to rise from around 23 years in 2000 to around 38 years in 2050. So this demographic shift underscores the growing importance of addressing needs and challenges of an aging population and in India, and it plays a critical role in shaping nation's future social and economic future landscapes. So as we see that there will be an elderly population in the next, say 25 years, there are some potential challenges. One is definitely economic burden, like with a significant rise in the elderly population, the economic burden on India's social security systems and healthcare costs is expected to increase. Unfortunately, there will be a decrease in productivity as the workforce shrinks due to the aging population. India's economic growth would be hindered. And as far as social challenges go, the traditional joint family system in India, which has historically supported the elderly family members, may face an increasing pressure. And with societal changes and urbanization, issues such as loneliness, elder abuse, mental health problems, among other elderly, among other problems that elder people face may increase. So these are some of the problems. Now there have been some reports, like there was a report by Niti Aayog, there was a report by KPMG, there was a report by PwC, which does address these challenges, but the gaps are that those reports are not holistic. They speak of the existing nature of the society while not underscoring any importance to the planning or policy making front. So these are the existing reports that I spoke about. As I mentioned, there are a lot of gaps. So can I go to the next slide?
Yes.
So there are a lot of challenges, and I'll probably share this. So the way forward in building a socially inclusive future for all ages, and this paper will deal with recommendations and will encompass a lot of interviews, where we'll do some content analysis of the interviews in filing those recommendations. So building a future-proof India requires a multi-pronged approach. By investing in healthcare infrastructure, skilling initiatives, and social security mechanisms, we can ensure the well-being of our senior citizens. Additionally, promoting intergenerational solidarity and leveraging the experience of senior citizens will enrich our society as a whole. These are some of the aspects and metrics that I'll be working on. One will be definitely the healthcare infrastructure for the senior citizens, promoting skilling and reskilling programs, uh, ensuring justice and legal protections, because that is what we've learned about in the last 1 month at IMPRI, strengthening social security and providing financial security. These are the 4 metrics that I'll be working on. Based on these above matrix that I spoke about, the policy level interventions that we may require moving ahead would be a national senior care policy, which will have a which will be a comprehensive policy that addresses healthcare, social security, skilling, and legal protections for the elderly. This policy should provide a framework for the state level as well as the national level implementations. National level and state level skilling and reskilling initiatives for seniors. A report should be launched, or a white paper should be, provided, that should address what is the, scenario in the job market, and how, there is a gap, and what is the existing scenario, and what are the gaps for senior citizens as far as the job market goes. Strengthening social security schemes. It includes expanding existing social security schemes like pensions, and exploring options for universal basic income for senior citizens. Legal aid for senior citizens, which provides access to free legal aid and representation for senior citizens, empowering them to navigate legal complexities and uphold their rights. Senior citizen friendly court procedures. This should include implementation of simplified procedures and dedicated support staff in courts to make navigating the legal system easier for senior citizens. The methodology that I'll be using will be a mixed method approach. One would be the content analysis of the existing reports and existing content. The other would be interviews with key stakeholders, which would be policymakers, NGO workers, senior citizens, industry leaders, government authorities. I'll try and get in touch with the state government as well as the national government, and content analysis of the reports like I spoke about, and also the content analysis of interview pieces, based on which some recommendations will be drawn on these 5 matrix, which is health, skilling, social security, financial security, legal aid, and all these 4 policy interventions that I spoke about. In conclusion, I would like to add that in our journey to becoming Viksit Bharat at 2047, supporting the aging population is crucial to enhancing the fabric of the society, and by proactively addressing their needs, including legal and social aspects, we ensure their well-being, dignity, and active participation in community life. This not only fosters intergenerational harmony but also promotes a culture of respect for elders, recognizing their contributions to the society. In this research, I will also do one thing, which is, providing a cohesive definition of what an elderly person means. Like, what is the age bar defined by the, census, defined by the government of India? What is the aging population? Like, what is the bracket? It will also have definition and points addressing challenges of various groups, vulnerable groups such as elderly people from the economically weaker sections, women and their empowerment, rural and urban population divide. And the limitations would be that since it is not an expertise of mine, I may not cover the queer section in this, but this is this is an overview of what I'll be doing and when I submit my research paper. Thank you.
Thank you. Now, I would like to invite Professor Vibhuti Patel ji for her remarks on this presentation.
Yeah. Janaji, congratulations for making such an exhaustive presentation, and you have already worked with the with the industry and also worked with the Niti Aayog. But I think the way you are putting forward as a challenge, economic burden, we need to learn from other countries. Like when Vietnam became independent in 1975, because of American bombing, 40% of the population either had one leg or no arms, or massive physical injuries had happened to the population. But it was the organization, the way they organized according to the ability of a person, using modern technology. They were making contribution to the economy. So I think putting it as an economic burden of senior citizen, I think we can learn a lot from East European countries, even some Scandinavian countries, where people are working even at the age of 82 and 85 because with the technological aid and nature of work changes. Like if you see in Singapore, you would see everyone working. Elderly people, earlier they were doing highly manual work and arduous work, long walking, long traveling. Later on in the old age, they are provided renewal, they have a renewal mission, no? So those who get displaced from one job, you get into another kind of a job. So you become a watchman, or you become a liftman, or you become a messenger. So that kind of. So this economic burden argument doesn't hold water if we see examples of several Asian countries, as well as even the war-torn countries, the way they rejuvenated, like Somalia or Rwanda, or even countries like, as I told, Singapore. Singapore was what? It was a monocrop country, small little city-state, no, only cultivating rice. And where is it? So it is also the public policy and the planning and how human resource planning you do. How did they opted when the economy was fast changing? At that time, they had a renewal mission. They give so many options to the workforce. Those who could not adjust to modern technology, or those who could, they were given different type of job of just this thing, or according to age and gender and the role in the economy. So I think that you just read little more literature and change your language, because this horror story of economic burden because of population is aging, it just doesn't go by the facts that we see. Japan, okay, Japan age at life expectancy has increased to 92. People are alive in one family. There are 4 generations, no? And how are they coping? And do you think that the economy has slowed down? No. There are so many other positive elements of reorganization of the economy, keeping the workplace closer to your to your residents. So many different methods that they have utilized. Or I saw in New York that all the vehicles had a disabled-friendly public transport. No, so people could not, even the person in wheelchair could go to the workplace, because that time the ladder would become a slope. So this kind of technology that they are doing. So the question of reduction in low productivity and economic burden, these two, I think you need to focus, do little more research. Another thing that you say that you will not include queer population in that, because whatever is applicable to all generations, or social security, social protection, all those 5 points which you have elicited, no, as a recommendation, I think that should apply to them also. Only one more thing you need for peer population is, because they are abandoned by their own biological family and they don't have support of their own biological, the kinship network, state has to take more proactive. So you need homes, the way we have a currently, what is it called? They call it dignity homes, no? For transgender population. Yeah. So in that, they have to give adequate budget. Unit cost has to be increased, no? So instead of leaving out those who are most marginalized, I think it's better to be inclusive. No? That's my suggestion. And there is UN Women has come up with the budget for gender responsive budgeting for transgender population. If you want, I can even share that document. But I think you should not leave it out.
That would be a
in your
great help.
recommendation. Yeah, because that would become a major point of criticism of your paper. You may be get lot of adverse remarks on
I
your
think,
paper.
ma'am, I'll definitely have to, get back to you for understanding more about this. Since, as I mentioned, I don't have many experts in my, I can touch base with, as far as getting, the queer part included in this. So I'll definitely, as you suggested, will take help from you. The paper that you,
And
also, sorry, the
your
budget.
discourse is very progressive. The alternatives you are suggesting, yeah, that they are excellent. All the alternatives you have suggested are excellent. Only thing, the language that you are using in terms of no community would like to be classified as burdensome.
Noted.
There was a time where they were all the policies and planners, if you see before 1975, were treating women as a burden. No, they were put in this because mufat ki roti todti hai. That was the kind of mentality even our economists and even our policy makers had. We changed after a 6 5-year plan because there was a towards equality report. They said no, women are not burden on the economy. They are making contribution because of their work is not non-market work. Non-market work doesn't mean that we are not contribution to the GDP. The invisible work or the non-recognized work or unpaid work, because women largely do unpaid work. And that we have to acknowledge. And then you can see in 2005, when National Institute of Public Planning and Policy prepared the first budget, gender responsive budget, in the introduction, they had run. Earlier, what was used to be the introduction? Indian women are largely housewives and they don't make any contribution, productive contribution to the economy. That language changed. And this NIPFP report says that we accept that when women entered the larger economy, they are already exhausted because they have done a lot of unpaid care work for the families, for the communities, and even for the economy, because you work in your farm, you work in the forest, but you are not paid. That doesn't mean that you are not contributing, no? So I think language is very important. So even with regard to person with disability or even elderly people, using the term economic burden is highly objective.
Noted.
But otherwise, it's excellent work that you have done. Yeah, a lot of labor has gone into it. We can see it. Yeah.
Thank you, ma'am. Thank you so much for your valuable insights.
Yeah.
Thank you, ma'am. Now, I would like to invite Advocate Dr. Shalu Nigamji for her remarks on this presentation.
Yeah, it's a wonderful presentation. You've done a lot of work, as Professor Patel has said. But just 2 points. One is about the how women are being treated in this entire periphery, entire scheme. Because when we talk about the single women, the widow women, because during the old age, the heterosexual families otherwise are not desirable, because the government, as we have Professor Saumya, she has discussed, that even in the programs and policies, we talk about heterosexual families, but now with the increase of single women who are coming in, so what are the provisions being made for single women, in all such policies, single elderly women? Second is about you talk about legal aid, to senior citizens. So in that case, there is a law which is Senior Citizens Act. So for that, the government has made special provisions. So you can look into that because there are very, very few studies being done on that law. So maybe how this law is being implemented, what are the problems litigants are facing while coming to the courts, because they have special provisions called, where you can go to a DM, like a district magistrate, or so what are the provisions being made there? Is there if people find it suitable or they're finding problem with it? So you can look into that aspect also.
You mean both 2007 and 2011, both?
Yeah, yes.
Definitely, ma'am. Thank you so much for your insights. And in fact, the point that you mentioned, single women, and I was just, going to add this into this women and their empowerment. There is a chapter that I'm planning to include. So definitely these insights and these points can be added to that chapter.
Yeah. Thank you.
I have a huge material with you. Yeah, and access also to all the official documents.
Sure, ma'am.
It's the advantage. Yes.
Thank you, Zarna Udasi ji. Now I would like invite anyone who would like to present their creative project.
Chahak ji, are you ready? Because today we had 3 presentations. Now Chahat ji, sir, if she's ready, then she can. Otherwise, we'll wrap up. Hello, are you there? Hello, Chahat ji, are you there?
Ma'am, she's not responding.
Okay, yeah.
Then, ma'am, we can move towards closing remarks by Professor Patel.
Yeah, okay. So, in the closing remark, I think first of all, we have to thank Dr. Arjun Kumar, Dr. Simi Mehta, and whole IMPRI team for such a nicely curated course that they envisaged, and also the excellent experts we got. And all these 6 days were highly productive. Lot of deliberations took place on critical issues at the intersection of law, public policy, governance, and social justice. And as it was declared in the statement in the course also, that the pursuit of justice has long stood as a cornerstone of human society, emphasizing inseparable link between law, democratic governance, justice, which is also with its ramifications as the social justice, economic justice, environmental justice, distributive justice, and also gender justice. And it is a fundamental and inherent human right enshrined in the Constitution, ensuring easy access to legal recourse. And all the sessions, the legal hand-ons of Dr. Shalu Nigam with a concrete grounded reality were extremely useful, insightful, and it also showed how we, once we are legally aware, how we can creatively use it. And in the contemporary times, we have seen that the efficacy of the rule of law is intimately tied to accessing the justice, and especially those for the vulnerable section of society, judicial activism, right to information, lok adalat. All these things are important instruments, and even global instruments, the way that the movement has used global instrument for fight against manual scavenging and also the caste-based discrimination. The administration of justice serves as a mechanism through which rule of law upholds rights and also ensures equitable treatment to the citizens. Innumerable examples were shared by the experts from different regions, from different sections of society, and from different historical period, and how slowly and gradually our horizons of the human rights and affirmative action started expanding. And we have seen the timely and convenient pursuit of justice. I think the very first lecture by Mr. Shailesh Gandhi was on the timely justice. The justice is delayed, is justice denied. That's what he said. So what kind of legal avenues we have? The pressure of almost all experts, they say that law alone is not enough. We need to have people's movement. We need to have the social movements which can ensure that principles of impartiality or transparency or effective justice or accountability of the governance structure is ensured. And that is why access to justice that should be equally available, irrespective of your caste, class, ethnicity, color, race, ability, religion, and all the other forms of intersectional vulnerabilities. I think they can be addressed by the social movement. We also had a very detailed discussion on the UN system and what kind of global instruments we had, whether it was a CEDAW or various covenants or 4 generations of human rights, and also some special this thing about the cross-country relations and the policies which the nation states are adopting. So I think that is also important subject. And in the Indian context, access to justice, it not only a fundamental aspect of rule of law, but it also protected by our domestic law, and we have drawn heavily on the International Human Rights Conventions, right from the Article 14 to Article 21 of Indian Constitution, the individual fundamental right to access to justice and the principle which are upheld by the lower courts, session courts, high courts and Supreme Court, and so many landmark judgments which were discussed by several experts, Dr. Shalu, Nigam, Dr. Vaidya Nayanar, and Dr. Saumya Uma today. I think they have enriched our understanding and made us more confident to use these instruments as conscious citizens, as legal practitioners, as researchers, and as academicians and teachers and trainers. So I think legal aid programs or campaigns play a pivotal role in expanding access to justice for all members of society. I think that is the learning we have had of all these 6 days and 18 sessions. Thank you.
Thank you, ma'am. As we come to the end of the LPPYF Law and Public Policy Youth Fellowship Cohort 3.0 Summer 2024 Advancing Justice, Bridging Gaps in Public Policy Enforcement, an online national summer school program, a 1-month immersive online law and public policy awareness certificate training course and internship program, I, Ritika Pandey, researcher at IMPRI, Impact and Policy Research Institute, would like to propose the formal vote of thanks on behalf of IMPRI, New Delhi. We are grateful to our experts for the Day 6 session, Professor Vibhuti Patel, Professor Saumya Umaji, for taking out their valuable time and allowing us to learn from this online certificate program. We extend our heartfelt gratitude for all the experts who guided us throughout this fellowship program. We thank our chair, Professor Vibhuti Patel, and our legal advisor, Advocate Dr. Shalu Nigam, for convening all these sessions. We thank all of our participants who have raised pertinent questions and actively participated in the deliberation throughout this program. A feedback form will be shared with you all via email. You will receive the certificate after the submission of the feedback form. We are grateful if you are watching us later on YouTube or listening to us on various podcasts or reading our publication. We hope you continue to join in future to our IMPRI Web Policy Talk and Web Policy Learning. Wishing you a good evening. Thank you.
Thank you so much. We are so privileged.
Thank you, Ritika. Yeah, I think all of us, your participants, made the discussion and deliberation so lively and kept us motivated till the end. So very important discussions. And Dr. Shalu Nigam, yeah, you want to have last words? She's the one who had curated the course in collaboration with the IMPRI team.
Just would like to thank you, ma'am, for for chairing this, all these sessions and so wonderfully, bringing together the data which is presented by different speakers. So thanks to you, and thanks to IMPRI team for putting this program together, and thanks to the participants who have made a lot of efforts in presenting. Last week they have presented, and today also. So wonderful presentations. A lot of hard work has gone into it. So hopefully we'll have a beautiful publications in future. So thanks to all of you.
Yeah.
Thank you, everyone.